My name is Brian Webb. I am an attorney with the law firm of Inksman Johnson in Boise, Idaho. And today, I want to talk to you about how your company or business can obtain capital through a private placement memorandum. Securities and Exchange Commission regulates the issuance of all securities. Typically, the SEC and applicable law require an issuer to disclose important information about itself to the public, usually through a registration statement. This registration statement is very expensive, and a private placement memorandum may be a more feasible alternative. This is because there are exceptions to the general rule that all offerings of an issuer must be registered. Today I want to talk to you about some of those exceptions and how utilizing them in conjunction with the PPM can help you to raise capital. Before we go any further, my attorney is requiring me to tell you that this presentation is not to be construed as legal advice. I am not your attorney. This is for education purposes only. However, I'd like to be your attorney, and so I hope you contact me with any questions you may have regardless of where you are and where your company does business.
Okay, so first things first. What is a security? As a general rule, if a person invests money and they receive some type of evidence of indebtedness in return, and they expect to derive profit from the efforts of someone else, then they have received a security under federal and state law. Typically, the security is in the form of a stock or a bond, but it can also be in the form of a membership interest or a unit, sometimes is what they refer to them as, in a limited liability company. Today, we're going to talk about Section 3B of the Securities Act, which exempts securities and small offerings from registration, and Section 4.2, which exempts securities in private offerings. Now, it's important to point out that these exemptions from registration do not apply to any notice filings that are required by a state or federal regulatory agency or from omitting material facts or making misleading statements in your offering document. Now, so small offerings, those are exempt. Section 3B authorizes the SEC to exempt offerings that are less than $5 million. Private offerings are also exempt. Section 4.2 of the Act exempts from registration any transaction by an issuer not involving any public offering. Here's where Regulation D comes in. Regulation D was promulgated by the SEC under Section 3B and 4.2. So Section 3B and 4.2 of the Securities Act basically say, SEC, go regulate these small and private offerings. And so the SEC did exactly just that. And they enacted Rule 404, Rule 405, and Rule 406 of Regulation D. Now, Rule 404 and 405 were enacted under Section 3B, and they provide for two types of exemption from the registration provisions of the Securities Act, both of which do not contain restriction concerning the nature or sophistication of the purchasers. The exemption under Rule 404 provides for an exemption for offerings of up to $1 million to an unlimited number of purchasers, and the exemption under Rule 505 provides an exemptions for offerings of up to $5 million to a limited number of purchasers. Rule 506 of Regulation D also provides for a couple other additional exemptions which are in the nature of private offerings under 4.2 of the Securities Act. Now, those include a private offering made only to accredited investors, those investors that have a predetermined net worth or annual income, and also to those also to those individuals who are sophisticated purchasers, those who may not be accredited but have experience in business and financial matters and who are able to evaluate the risks of an investment. Common requirements for a Regulation D exemption include the restriction of no general solicitation or general advertisement. And an investor has to reasonably believe that I'm purchasing for the purpose of investment and not resale. Investors must file a Form D with the SEC, typically not later than 15 days after the first sale. And the purchasers of the securities must, almost in all situations, be sophisticated, as we talked about before, and have information of the company or of the security readily available to them. And typically they must agree not to resell or distribute their securities to the public. There are some other things to consider, as we talked about before. You're not exempt from the anti-fraud and civil liability provisions of the various federal securities law, or to furnish to investors whatever information may be necessary to make your offering as clear as possible. In other words, not misleading. You got to comply with state law, and you typically can't resell your investment without establishing some type of independent basis of exemption or registering your securities. Sometimes states are even more strict than the limitations that are required by Regulation B. And those states typically are, and that's referred to as blue sky laws. You've got to follow federal and state laws. Not one or the other can be followed unless either law says an issuer is exempt. There was an act that was enacted in a statute that was enacted in 1996, and it preempts state regulation of Rule 506. That's kind of the exception to the state securities law. States can't heavily regulate an offering under 506, but they still can require some notice. They still can require notice and some filings for the purpose of giving notice, and some filing fees along with that. So why do you want a private placement memorandum? First of all, you want to have significant protection for fraud claims under the Securities Act. You want your investors to receive the information that they need to evaluate the investment and make an educated decision. You're going to want some legal caveats in there to comply with federal SEC and state securities disclosures. And these typically aren't found in a business plan. And so the private placement memorandum, or PPM, offers a form of liability protection for business owners. The other reason is it's just professional. It makes you look like you know what you're doing and you're not a fly-by-night type of agency. A private placement, or PPM, should have a number of it. It should tell who the issuer is. It should show this is the business plan. And significantly, it needs to talk about risk factors. Why is my company going to fail? And it may sound silly, but it's how you obtain protection, liability protection under the Securities Act. It should include financial statements, how you're going to be capitalized, and if there's any exhibits that could include organizational documents or contracts that have been entered into, or other material information that would be important for an investor to have. So if you have any questions about this, I'd be glad to help you out. Please call. We do this type of work all over the nation. I'd love to help you. Area code 208-384-8588, or you can see my website at www.inksman.com.